As of January 2021, the U.S. government has a dramatically expanded ability to compel financial institutions to produce documents that are located outside of the United States in foreign jurisdictions. This is because of the National Defense Authorization Act for fiscal year 2021, known as the NDAA. And one thing that the NDAA did was expand the ability of the government to use Patriot Act subpoenas. Now, a lot of banks aren't that familiar with Patriot Act subpoenas because they haven't been used that much until this year. But that's likely to change now. And the reason for that is that the NDAA allows the US government to use the Patriot Act subpoenas to obtain many categories of documents they previously couldn't obtain. So it is critical for banks that provide correspondent banking services and banks located outside the United States to understand how Patriot Act subpoenas now work. So today I'm going to talk a little bit about the nature of a Patriot Act subpoena, how the NDAA changed how Patriot Act subpoenas work, and finally what financial institutions should do now to get ready for a future receipt of a Patriot Act subpoena. The Patriot Act is a law that was initially passed in the wake of the terrorist attacks on the United States on September 11th, 2001. And among other things, the Patriot Act created a mechanism that the US government could use to obtain documents that are located outside the United States from a non-US bank that had a correspondent bank account here in the United States. And often these are foreign banks that don't have a presence in the United States, such as through a branch or a subsidiary, but they have an account that they open to provide correspondent banking services at a US bank. And the type of correspondent services that they use are generally receiving payments in US dollars in the United States or making payments in US dollars on behalf of their customers that are located in the non-US jurisdiction where they're based. So under the initial Patriot Act subpoenas could only be used to obtain records that relate to the non-US bank's correspondent bank account in the United States. So obviously that's a small fraction of the overall records that most foreign banks have. Any of the records that they have that don't relate to their US correspondent bank account didn't fall within the scope of a Patriot Act subpoena as those subpoenas were initially defined. But all of that changed in January of 2021. The NDAA made Patriot Act subpoenas a much more powerful tool for the US government in a number of ways. First of all, it expanded the scope of the documents that can be requested by the US government by expanding it not just for documents that relate to correspondent bank accounts in the US, but they can now be documents that relate to any accounts at the foreign bank, as long as that bank has a correspondent bank account in the United States, and as long as the investigation relates to either a criminal investigation, a civil investigation, or a number of different kinds of administrative investigations that relate to the Bank Secrecy Act. In addition, the NDAA creates a powerful stick for the US government to use if foreign banks don't produce those documents. They can be penalized $50,000 per day for not complying. In addition, the foreign banks are prohibited from notifying the account holder about the request. And this can create a problem for a bank, which relates to the next way in which this is a substantial change, which is that often it's illegal in a foreign jurisdiction to comply with the US's request. Foreign banks are often in a situation where it's actually illegal either to produce documents because of privacy laws or to produce documents without notifying the account holder because of laws protecting the account holder. However, the NDAA explicitly says that just because producing the documents would be illegal, that's not by itself a sufficient reason to quash the subpoena and prevent the US government from getting those documents. So in light of all of these changes, it's very important for financial institutions to be prepared when they receive a Patriot Act subpoena. There are a number of things that financial institutions should be considering now because of the passage of the NDAA. The first is that the actual text of the NDAA may not ultimately define the ability of the US government to use Patriot Act subpoenas. And that's because, separate from the law itself, the US Constitution puts restrictions on the ability of the US government to haul people located outside the United States into US courts and compel them to provide documents. It's likely that some foreign banks are going to use those constitutional arguments to try to limit the ability of the US government to seek documents that are located abroad. So the scope of the US government's use of the Patriot Act subpoena is likely to vary over time, partially in response to those judicial rulings. In addition, non-US banks that have correspondent bank accounts in the United States should be aware that they're more likely to be pulled into US criminal investigations. So there's a couple things they should do in response to that. One is just look at their own anti-money laundering policies and procedures and ensure that they are going to be able to withstand scrutiny from the US government, because they don't want to be hauled into an investigation and ultimately incur liability as a result of one of these investigations that use a Patriot Act subpoena. Similarly, what they may want to do is reconsider some of the clients with which they do business. If they think that they're providing services to a client that is likely to be the subject of a US investigation, they may want to de-risk by getting rid of some of those clients. In addition, US banks that provide correspondent banking relationships to some of these foreign banks may want to reconsider whether they're going to continue to provide those services. They're more likely to themselves be pulled into investigations, for example, money laundering investigations, that originate as an investigation into the foreign bank, but end up implicating the US bank because of the correspondent banking services that the US bank is providing. So the terrain isn't yet clear about how Patriot Act subpoenas are going to be implemented, and it can be a little bit confusing, it can be a little bit tricky, and the stakes are quite high for financial institutions both in the United States and outside the United States. But good news, I'm a lawyer. So if you have questions about the NDAA or how your financial institution can respond to a Patriot Act subpoena, give me a call. I'd be happy to talk to you.